Greg that link, the one that you have. What did I say? Okay. Yeah, would you mind doing that? Okay, so we're going to get started today. Hi, everyone. I'm Nancy Hoffman-Banyek, and I'm CEO of the Greater San Fernando Valley Chamber of Commerce. I want to welcome everyone to the Chamber's 2020 Labor Law Update presented by Kristina Kourasis of our partner Landegger Law Group. Today's webinar will provide you with the latest California employment law-related updates, compliance, and regulatory issues. You'll get comprehensive, actionable programming that provides you with the information you need to protect your organizations and manage your company's risk. Following our webinar, we will send out a follow-up handout that you can refer to in the future with information from today's webinar. I also want to remind everyone that there have been significant changes to required labor law posters, the ones you post for your employees in your break rooms. If you do not have the new 2020 posters for state and federal, the Chamber does have them for sale, and we're about to place a new order. So anyone on the call today, if you're a member, you'll get our Chamber member rate, and if you're a guest, we will extend you that rate as well through the end of the month, just Friday. Link to order will go out with the handout for the email. If you are on this call and you are seeking credits for SHRM or HRSI, reply to the handout email and we will send you your certificate. A couple of housekeeping tips. We have everyone on mute. If you have a question, you can type it into the webinar. There's a place for you to ask questions, and depending on time, we will take them as we go or we will take them at the end. Everyone can see the questions if you have the window open, and that gives you an opportunity. There's a thumbs up, and you can upvote, meaning if you have that same question, click the thumbs up, and it will push that question up in queue, because if multiple people have the question, we know it's a burning question. And now I would like to introduce our speaker, Kristina Kourasis, Esquire. Kristina received her JD from Southern Western Law School in 2011, where she served as a judicial extern to the Honorable Philip Gutierrez of the Central District of California, and edited the ABA's Journal of International Media and Entertainment Law. She received her BA with honors from the University of Southern California in political science with an emphasis in philosophy in 2001. Before joining the firm, Kristina specialized in complex business litigation at Stris & Meyer, LLP, focusing her practice in areas of employment, employee benefits, and healthcare litigation. Prior thereto, Kristina ran a solo practice devoted to advising employers in employment law matters and representing employees in a wide variety of employment disputes. She is a member of the Labor and Employment Section of the State Bar, the San Fernando Valley Bar Session, and the Eastern European Bar Association. Take it away, Kristina, and let me give you control of the remote.
Thank you, Nancy. Good morning, everyone. As Nancy mentioned, I'm Kristina Kourasis with Landegger Law Group. Thank you, everyone, for joining us this morning for a 2020 legal update for employers. I'd like to begin now. As you may have figured, I'm trying to get control of this PowerPoint. Give me just, there we go. As you may already know, the California legislature, as well as our governor, has been very, very busy. And especially the two were very busy in 2019. So just to give you an idea of how busy they were, the state legislature sent over 1,000 bills to the governor. Okay, and Governor Newsom signed 870 bills, to be exact, vetoing only about 172 of them. Nancy, I'm having issues with the control for some reason.
Is that what you want?
There we go. So let's just keep going. I believe so. I'm still not able. There we go. Okay, I'm good. Excuse us. So of the 870 bills that were actually signed, many of them will unfortunately affect the way employees do business together. I am still having issues with the control.
Okay, hold on a second. Let me see what's going on.
To move forward.
I don't know where you have control, but let me move it forward for you.
Okay, that would be really great. So, you know, one of the most instrumental issues that, you know, one of the most instrumental laws that went forward is the law governing the employment relationship between an employer and independent contractors. Okay, and here's what happened. Generally, employment laws do not apply to independent contractors, as most of you probably know. However, under the new laws that came down the pike, workers performing work for an employer are actually presumed to be employees of the company, right? So this transition, as many of you know, began as early as April, in April of 2018, with the decision properly pronounced as the Dynamics v. Superior Court of Los Angeles, right? And what happened back in April of 2018 is that the California Supreme Court issued this decision that provided us with what's called the ABC test, okay? And the ABC test requires employers, Nancy, if you can move forward the slide, please, requires employers to be able to overcome the presumption to prove all three tests, A, B, and C, right? Under A, an employer must prove that the employee is, or the worker rather, is free from the control and direction of the employer in the performance of the work. Under the B prong, the employer must prove that the work is outside the usual course and scope of the company's business. And under the third prong, prong C, the company must prove that the worker is customarily and regularly engaged in an independently established trade, occupation, or business. Okay, and that was the Dynamics decision. Now, as of January 1st of this year, next slide, please.
I gave you that control again, so try it.
Okay, I am trying it. Let me see.
Okay.
Okay, so as of January of this year, AB5 actually codifies and expands Dynamics, okay? So what that does is now there's law that applies beyond just the wage orders and to the California Labor Code and Unemployment Insurance Code, okay? Now, even though, as you can tell, the law is now very expansive, there is a piece of good news, right? And that is that AB5, beginning in January of 2020, creates a number of exemptions for specified occupations, okay? And the next slide will show you a list of the professions that are exempt from the Dynamics test, okay? And the list includes insurance brokers, physicians and surgeons, dentists, podiatrists, psychologists, veterinarian, lawyers, architects, engineers, PIs, security brokers, salespersons, commercial fishermen, and newspaper distributors and carriers, okay? In addition to that exemption, under AB5, there's also another exemption called the professional services exemption. And under that exemption, an individual will be exempt if the following factors are established. The individual maintains a business location that's separate from the employer. The individual has a business license. They set their own rates, their own hours. They do the same type of work for other entities or hold themselves out, for example, via a website that this is the type of work that they do. And they, in exercising or performing the work for the company, they use full discretion and independent judgment during the performance of that work. Okay. Here's the following professions are exempt under this professional services exemption. The marketing professionals, HR administrators, travel agents, graphic designers, grant writers, fine artists, photographers and photojournalists, freelance writers, editors, and various specialists in the hairstyling industry, hairstylists, barbers, cosmetologists, and estheticians. Okay, this list also includes individuals in the construction industry, for example, subcontractors. However, the following criteria has to be met for this exemption to apply. First of all, and the key requirement is that the contract has to be in writing, okay? The subcontractor has to be licensed and maintains a separate business location, has authority to hire and fire others, assumes financial responsibility, and is customarily engaged in an independently established business of the nature of the work that's being performed, okay? Another type of exemption is what's called the business-to-business services exemption, okay? This is basically two businesses contracting together to do something, right? This also may apply, because a lot of my clients ask me, well, I'm just myself, a sole proprietorship, could this apply to me? Yes, it can if you meet, the following requirements, right? Again, the service provider has to be free from control and direction of the quote-unquote employer, right? And the other key component is that the service has to be provided to the business as opposed to the customers of the business. So if you're providing the services directly to the customers in any way, for example, I have a Zumba fitness studio, and if the service provider is actually training the Zumba company customers, then that is a no-go. In other words, the service has to be provided to the company. So if the service provider does plumbing, accounting for the Zumba studio, that's fine. But if they are just another instructor who's teaching the customers directly, that is a non-starter, right? That isn't going to fly under this type of exemption. So the key is that the contract has to be in writing. Okay, they have to be licensed or have to have tax registration if applicable. They have to have, again, a separate business location, and they have to be engaged in an independently established business. So again, I always recommend to my clients that they have a website, that they advertise themselves somewhere, so that if anybody looks them up, for example, an agency that's auditing the business, they can see, okay, these people are set up properly. They definitely are running a separate business, right? So there's less of a chance of misclassification there, okay? So the other thing is, not only are you advertising yourself, you should also actually be providing services to other businesses. So there'll be, an agency that's potentially auditing you will be looking for, hey, is there another contract? Do you have an established business service relationship with another entity, right? That's really key to, authenticating that business-to-business services relationship, okay? So another thing, as I previously mentioned, is, you have to show that you can negotiate your own rates, that you can set your own hours, that you have your own location, and the type of service that's provided doesn't require a CSLB license in the context of this exemption, okay?
What's CSLB license?
This is a type of license that's, that requires a specialization, and I think that the individuals that are engaged in any industry that requires that type of license will know what I'm talking about.
Well, can you say what it is spelled out?
Sure. I'm happy to address it.
I just want to know what it stands for, Kristina. What's CSLB?
It actually stands for, sorry, I'm trying to.
Okay, we'll get back to it.
Yeah, it's something that I'm happy to discuss in detail.
It's a contractor
later on, but I want to just keep
state
going.
license.
Yeah, it's a type of contractor license that is required, for certain industries, okay? So the next type of update that I want to really emphasize is under AB 51, okay? And it's a very, very important update. What it is that it adds section 432.6 to the California Labor Code. And what it is trying to do, because the law is currently stayed, is it's trying to outlaw mandatory employment arbitration of claims by job applicants or employees, okay? So currently, AB 51, as written, prohibits mandatory arbitration agreements for any discrimination claims covered under FEHA, and for any claims under the Labor Code, including wage and hour and other protections. The key, though, is that if this is the type of agreement that you think your company would benefit from, you should feel free to give me a call or send me an email, and I'll talk to you about whether this is appropriate for you. I think the benefits of this type of arbitration agreement is that you can, if you're a big enough company, that you can get a class action waiver. In other words, your employees can waive the ability to file a class action against you. However, they can still file what's called a PAGA claim, a Private Attorney General Act claim. So depending on the size of your company, it may or may not benefit you. It's very expensive to arbitrate. So, feel free to contact me and I'll provide a free consultation about this. The point is that the law is currently stayed. So there's a small window of time for you to decide whether this is right for you to waive a potential class action. And if this is something you want to do, you should pursue it now, okay? So let's move on to the next one, which is the AB 9, that basically extends the statute of limitations from 1 year to 3 years for an individual to file or report a harassment action, okay? So beginning January 1st, 2020, the statute of limitations for an employee to file an administrative complaint for discrimination, harassment, and retaliation with FEHA is extended from 1 to 3 years, okay? So, and this bill, however, will not revive any claims that are already lapsed, okay? So let me move on to the next slide, if I still can't. So the next key thing, and I think most of you are probably aware, effective January 2019, all employers with at least 5 employees were required to provide sexual harassment training by January 1st of 2020. Well, luckily, there was an extension, and now if you haven't done it in 2019, make sure that you do it this year and get your employees and staff trained, because the requirement is now due by, was extended to January of 2021, and specifically, employers are now required to provide at least 2 hours of sexual harassment training to supervisory employees, managers, and at least 1 hour of training to non-supervisory employees, okay? And subsequently, once they do receive the training by the deadline, they have to renew their training every 2 years thereafter, okay? The next law, AB 547, requires the director of the DIR to convene a training advisory committee to assist in compiling a list of qualified organizations that janitorial employers must use to provide in-person sexual violence and harassment prevention training every other year. Under SB 530, employers who have seasonal temporary employees who are hired to work for less than 6 months have until January of 2021, so another year, to provide training, under the existing sexual harassment training requirements and education requirements. So you still have time, but don't wait too long, just get it done. And this law also allows for employers in multi-employer collective bargaining agreements to satisfy any anti-harassment training by verifying that they have requisite training under the existing sexual harassment training and education requirements. This next item, the lactation accommodation law, was updated significantly. So you definitely want to make sure that you're compliant, because if you have employees, it applies to you, okay? So under the current state law, the location for an employee to express breast milk may not be a bathroom, okay? It must be a private location in close proximity to the employee's work area, okay? Under SB 142, which is the new law, it adds specifications. In other words, the room or the area that you're providing must be shielded from view and free from intrusion. It must be safe, clean, and free of hazardous materials. It has to have a surface where the woman can place a breast pump and personal items. It has to have a place where she can sit and be able to access electricity or alternative devices. There must be a sink with running water and a fridge for storing milk. And other cooling devices are also acceptable, like a cooler. And if it's a room that has, that's used for other purposes, the lactation process must take precedence over other uses. It also requires, this new law requires that you have a written policy to be distributed upon hire and upon inquiry by an employee. So if you don't have one, feel free to give me a call and I'll put one together for you. Okay, this next law, AB 749, is related to settlement agreements. And what it does is it prohibits employment settlement agreements from prohibiting an employee from obtaining future employment. So in other words, a clause that basically says, employee acknowledges that he or she will not apply for work at the company, right? That's no longer allowed in this context, okay? So an employer, however, may still lawfully prohibit or restrict an employee from obtaining future employment with the settling employer if the employer has made a good faith determination that the employee engaged in sexual harassment or sexual assault. And I'm sure you all understand the implication of this public policy. And again, any settlement agreement that violates this prohibition will be deemed void as a matter of law and against public policy. The next law, SB 83, provides an extension of the paid family leave benefits. So beginning July, not January, but July, the maximum duration of PFL benefits is going to be extended from 6 weeks to 8 weeks. So that's really good news. And it's going to remain effective until January 1st, 2021, at which point it's going to be reassessed. Another, I think, really revolutionary piece of law that came down the pike is SB 188, and what it does is it bans discrimination on the basis of hairstyles associated with race, which I think is really cool, and it's called the Crown Act, and it basically adds hairstyles that are closely associated with race to the class of protected racial characteristics, including hair texture, hairstyles such as locks, braids, and twists. Okay, and obviously this is not an exhaustive list. The next piece of law is AB 673, which expands Labor Code 210 by allowing an employee to recover a penalty from an employer for late payment of wages. Now, the key part is that this is during employment, in contrast with post-termination under Labor Code Section 203. So now you got to realize that if you are late in paying those wages to an employee, even if it's inadvertent, okay? I know the code says willful, but the fact of, late payment is sufficient to trigger this penalty, okay? And the penalty is pretty hefty, okay? It's $100 for the first violation and $200 for each subsequent violation, plus 25% of the wages paid late. So here's an example. If an employee earns $1,250, they can recover as much as $400 and the $100 penalty plus $300 for each subsequent violation plus 25% of the wages paid late. So it's very sizable. So you want to be very careful with that. The next law that's being updated is SB 688, and what it does is it expands the Labor Commissioner's citation authority to include citations for failure to pay wages promised by contract or agreement, whereas before the Labor Commissioner only had authority to cite for failure to pay minimum wages. Now it's basically whatever you had a promise to pay, okay? The contract doesn't have to be in writing. It can be verbal agreement to pay, X number of dollars. And if you fail to do that, then they can come after you, okay? So be careful. The next update is of the mileage rate. Okay, the standard rate will now be slightly reduced from 58 cents to 57.5 cents. So you save a whole 5 cents per mile, something, right? And then obviously they make up for it in the California minimum wage, right? So the minimum wage, the California minimum wage each year on January 1st from 2017 to 22nd, with the goal being $15 per hour by 2022. We're now looking at, if you're a company that has employees of 26 or more, then you're basically going to have to pay $13 per hour. And if you're 25 or less employees, $12 per hour, okay? And we have a chart that's coming up later on in this PowerPoint that you can take a look at to see where you're located and if you're in the city of LA. Okay, so city of LA.
Kristina,
yeah,
I want to interject that we're getting some questions that we'll take at the end.
Okay, excellent. So in the city of LA, effective July 1st of 2020, you basically have to pay $15 per hour for employers with more than 25 employees, and $14.25 for employers with 25 or less employees within the city. Okay, and even if your address says Los Angeles, there's a way that we verify to make sure that your specific address falls within the city of LA. So if you have any doubt whatsoever, you should definitely double check. Feel free to contact me, and I'll consult you for free. Make sure that give you that peace of mind whether you do or don't fall within the city of LA, because it does make a really big difference. Los Angeles County has the same schedule as the city of LA, and then you also want to make sure if you're in the incorporated versus the unincorporated areas of Los Angeles County. So, for example, Marina del Rey, Calabasas adjacent, or Universal City. Those are some examples of unincorporated areas. You want to make sure to check your local ordinances for minimum wage requirements. For example, I'll give you an example. One of my clients is located in Burbank, okay? So she contacted me and she wasn't sure, because it seems like, oh, Burbank is in the city of LA, but in fact it isn't. It's not in the city of LA. And you want to make sure to first make sure, okay, am I in the city of LA? Okay, I'm not. But then also double check, is there a local ordinance, for example, the city of Burbank, that has its own minimum wage ordinance that, you have to comply with? Okay, if in doubt, again, feel free to contact me and I will, I'll make sure that you're complying. So that's the chart, the California minimum wage chart, the hourly. This chart that's now showing on the PowerPoint is the annual salary requirement for exempt California employees, okay? And it is also made to apply to, depending on the number of employees that you have. So looking at the 2020, that's the numbers that are in red. If you have 25 or less employees, the minimum salary that you should be paying, now we're talking about salaried exempt employees, should be $49,920. And, weekly that translates into $960. And if you're 26 or more employees, then you should be paying $54.80 to your salaried exempt employees. Again, if you have any questions, feel free to shoot me an email. Okay, so the next slide is concerning the mandatory retirement savings program. Make sure that you look into this. Under SB 1234, was actually enacted back in 2016, requires a workplace retirement savings program, CalSavers, for private sector workers whose employers do not offer a retirement plan. And you can take a look at the size of the business to see what applies to you and the deadline by which you have to comply. Okay. The next slide concerns reporting of serious occupational injury, illness, or death. The existing law basically requires employers to report any workplace injury or illness resulting in lost time beyond the date of injury or illness, or that requires medical treatment beyond first aid within 5 days of the employer's knowledge. Okay. However, take note that effective January 1st of 2020, employers are required to immediately report any serious occupational illness, injury, or death by phone or an online mechanism that's still in the works. It's not set up yet. So basically, until that mechanism is set up, you're required to report by telephone or email, and failure to do so is subject to a very, very, very steep penalty of $5,000, okay? The next law concerns organ donation leave, and under current law, employers with 15 or more employees are required to provide eligible employees with 5 days of paid leave for bone marrow donation and 30 days of paid leave for organ donation. But starting in 2020, employers are now required to provide a maximum of 30 business days of unpaid leave in addition to the original 30 days of paid leave in a single year. The next law, AB 61, states that effective September 1st of 2020, an employer or a coworker who has, open quote, substantial and regular interactions with the person being restrained and with approval of their employer may seek an ex parte court order for 1 year or renewed gun violence restraining order against an employee or coworker. So with all these laws in the works, I really want to emphasize the importance of managing your business to ensure that you're compliant, because, for example, with respect to the independent law, AB 5, depending on the type of business, the nature of your business, you may be audited more heavily. For instance, my clients in the cannabis industry are definitely at the top of that list to be audited. So you really want to make sure that if an agency is randomly auditing and calls you up or sends you a letter requesting documents, that you're compliant, okay? Make sure that you have someone, feel free to call me, look at your pay stubs to make sure that you have everything listed that's correct. Make sure that you're properly paying, that your minimum wage is in compliance, okay? But also, notably, ensure that your employment policies are up to speed. First order of business, if you have any employees, make sure that you either have robust written policies or an employee handbook, depending on the size of your company. If you have enough employees, I may recommend that you have an employee handbook, okay? So make sure that you draft and implement policies that comply with the law, and make sure that you're uniformly applying those policies to everyone, okay? I cannot emphasize enough, you must apply your policies uniformly, okay? Make sure that you're reviewing and updating your policies. So if it means sending them over to me and you know, saying, hey, you know, can you take a look? You know, I want to make sure that I'm compliant. I'll walk you through the checklist, make sure that you are complying, and at a minimum, make sure that you have all the required forms that your employees have reviewed and signed for, okay? Also, it's very important that you train your staff, okay? Especially anyone in the supervisorial capacity, managing capacity, you want to make sure that they are recognizing any risks. I mean, I cannot emphasize enough, I go and do sexual harassment trainings, and the questions that come up sometimes just, you know, are astonishing, you know, the types of questions that are being asked. So make sure that your staff understands the risks. If you have supervisors, make sure that they are trained. I suggest, even though the deadline for sexual harassment training is January 2021, that you get it scheduled and done ASAP. And you can get it done through various providers. Depending on the size of your company, you can get it done online. It's probably going to cost you like, I don't know, $39.99 per person, okay? Depending if you have a, you know, very small company. If you have a larger company, you know, give me a call and I'll give you a really competitive rate. Come in and do an interactive training in-house, travel to you, and get it done, okay?
Or you can also use chamber members. No offense, I want to make sure we
absolutely. You should feel free to use chamber members. You should feel free to use any online providers. Like I said, it really is a business decision. So depending on your needs and the size of your company, you know, get it done though. Get it done as soon as you can, right? Right, Nancy?
Yeah, exactly. As soon as you can.
So, yeah, so I mean, I think that, you know, one of the things also in this chapter of, you know, managing the risks, it's really important that you have proper documentation, okay? A lot of our clients, you know, come to me and I ask them, you know, they get a threatened letter, a letter of a threatened action, and I say, you know, they're requesting your, you know, personnel file and payroll file, and they're like, what's that? Okay, you definitely want to make sure that you keep all the personnel file stuff in one file. Again, if you have any questions, let me know, and you know, I'm happy to send you a free copy of our you know, required forms and new hire documentation. This is the type of stuff you need to keep in the personnel file. Make sure that you do have, you know, compliant pay stubs, that you keep payroll documents on file, because you know, there is a requirement under the labor code section that if it is requested that you must turn it over, and if you don't, then you'll be subject to penalties under the labor code, and they really are, you know, pretty steep. Another option that, you know, we may or may not recommend to you is the Employment Practices Liability Insurance, the EPLI. And under that, you know, what it is basically insurance, okay? And it's insurance for certain types of employment law claims, okay? Now, they generally don't cover wage and hour claims, but there may be a policy that, you know, depending on your size, may be appropriate to you that can cover at least your attorney's fees if it's, you know, a straight up, you know, wage and hour action or something that contains wage and hour claims. So definitely check into all these things. And I know that the chamber, you know, the chamber membership definitely has many members who are in the insurance industry. So you definitely want to inquire, okay, and use your members as your partners in this business. Okay, that's all I have for now, and I think we'll at this point.
I'm going to start giving you some of the questions. We've received some questions, so let's go through them. There's not a lot. This is a few people asked the same question. Is there a late? Is the late payment for late wages per employee? So if you have several employees and you pay all of them late, is it one penalty or is it for?
No, it's actually per employee. So it'll be very hefty if you have a systematic, you know, late payment. For example, a lot of, I don't want to say a lot of, but sometimes it so happens that you use a payroll company that's not, up to speed on these things, right? And let's say you end up with a payroll company that's sending things, a few days late, okay? You are unfortunately going to incur, sorry about that, a penalty per employee, okay?
Okay, sorry, that was me putting it on speaker again. Okay, the next question is, when are the late wage penalties effective? Is that 1/1/20?
Well, I'm sorry, I
when
lost
is the
it for a second.
when is the late wage penalty effective? When does it begin? Did it already start?
Yeah. Oh, yeah. Absolutely. It's effective beginning January 1st of 2020.
Okay, so January 1st, 2020.
And I want to draw a distinction that you're referring to the late wage penalty during employment. Okay. And yes, it became effective.
Okay.
Okay.
I'm kind of typing back to some people, so.
Because I want to draw a distinction.
For current employees, it became effective became effective 1/1/20. Okay.
Yeah.
Okay.
Exactly.
The next question is, and it goes back to AB5.
Okay.
This company is a property management company, but they also own their own buildings. They have a building that's a hotel with a bar and a bowling alley, and each week they hire a garage band, for music, so they can showcase their music to the bar patrons. So it's once a week. They're telling them that they now can't hire them for the evening unless they get a business license. Are they doing that correctly?
Yes, they do need a business license for this to be a proper business-to-business exemption under AB5. Okay, and in all fairness, even AB5 aside, they really should have a business license if they are doing this commercially. Okay, if the band is going around and providing services and making profits or whatever, whatever it may be, grossing from their appearances, they really should have a business license because they have to pay taxes to the city for running their business.
Right.
Okay.
What if they're not being paid? What about all these bands that go to places and do it for free?
Well, I mean, it really does depend on the setup, right? But in this type of context, they definitely should get a license, and it shouldn't be that difficult. And if they're grossing under, X number, it's a six-figure, which I suspect they are, they are not going to be liable for any taxes to the city whatsoever. So there's really no reason for them not to get a license set up,
Okay. The next question. So for wages, every 30 hours worked, you get 1 hour of sick pay. I also know that. You don't pay out for sick pay at the end of the year. If an employee has some sick hours and would like to use it, as an employer, do you have to give them those sick hours? Well, basically, with the new sick pay, I know for us, for instance, because we front load, we have to roll over so many days into the next year, correct? So can you explain how that works?
It really does depend on where you are located. So I'm happy to look into for free, honestly, feel free to send me an email and I'll look into your address, because without the address, I will really have trouble giving you a definitive answer. But you really should just shoot me an email and I'll double check for you. But
I'll connect you with this person.
Okay, I'm happy to look into it for this person for free, okay?
Okay. So if someone has a business in the city of Claremont, but their delivery drivers go everywhere, including Los Angeles, once a week for an hour, how do they pay their minimum wage? This is always our favorite question.
Okay, so in terms of minimum wage, so City of Claremont, I don't know if they have a local ordinance. This is one of those things that we really need to look into. Again, this is another question that can really benefit from having me look into it. But what I really want to say is that depending on whether or not you're in an unincorporated area of Los Angeles County, or if it's a separate ordinance that governs you, it's going to really depend on, the ordinance that governs your minimum wage. And I honestly cannot tell, whether the City of Claremont has it or not. And also, whatever the address is, it may or may not be within the boundaries. It may be outside of the boundaries, even if it says, you know, City of Claremont.
But the question is, because I know this came up a couple of years ago when they did it.
Yeah.
Your business is in one place, but the minute you drive into the city of, let's just say Claremont's minimum wage is $10 an hour. Once you drive into the city of LA, you're supposed to be paying them that minimum wage.
That's absolutely correct. And I think the requirement is if you work something like, I don't know how many X number of hours, it may be as low as like 2 hours a week, okay? So, or 2 hours per pay period. It's very, very low for you to have to satisfy the Los Angeles City minimum wage requirement. So you definitely want to, first of all, have a definite understanding of, you know, how many hours are these employees performing work in the city of LA, okay? Because if they're performing, you know, the minimum requirement, for example, you know, 2 hours of work per pay period in the city of LA, then they may be on the hook for the, you know, the city of LA minimum wage. And beginning 2020, depending on how many employees you have, if you have 25 or fewer, that will be $14.25 per hour, okay? And if it's, you know, 26 or more, then you're on the hook for $15 an hour. Now, if that area happens to be unincorporated, I don't know where they're, you know, that's another thing. I don't know where they're commuting to, you know, are they commuting all around the, you know, Los Angeles city?
If they're driving, this came up first with a member before. Their drivers go everywhere. So they're based in Burbank, they go into the city of LA, then they go to the city of Calabasas, and they go to the city of Thousand Oaks, and then for a hot second they're in an unincorporated area. And I know at that point, they're your client now, they just decided it was easier than to have a phone with a GPS just to pay whatever the minimum wage was in their required city for all of those.
Well, here's the thing, Nancy. Here's the thing, Nancy.
Higher.
City of Burbank is not part of the city of LA.
I know that. I just said that.
However,
there's many individual municipalities. The city of Los Angeles includes the San Fernando Valley, except for Burbank, Calabasas, San Fernando, Glendale, and we know that. What I'm saying is they are in the city of Burbank. I'm just saying. So I know it's a city,
I understand.
but then they drive into these other cities and unincorporated areas. In this case, and it was your law firm, because and I don't know if they're in Burbank, whatever city they were in was higher minimum wage than those other ones. So
how many employees do they have?
Okay, I'm just giving you the story, okay? So they have 1,000 employees, but regardless, it was easier to pay the higher minimum wage across the board than to calculate every time someone crossed into a different city line.
I completely agree with that approach. If you pay $15 an hour, that would be the conservative approach to take to make sure that you're in compliance, especially since you're crossing all over the board, including Los Angeles and unincorporated areas of Los Angeles County. I think $15 should be the absolute minimum that you pay per hour.
I'm just saying, because this is not the first time we've had this question since the minimum wage law went in for people who drive into other areas, and their drivers having to have separate GPS things. You don't know when you cross into another border sometimes. Right.
No, I totally agree. Yeah, it's a good question.
Okay, so I hope we answered that question, because that goes with the other one, but then it was followed up with, if you have an employee that was hired in one location, but then 2 days a week they go to another city, and then minimum, and then, but they're technically the employment's in Thousand Oaks, but then they're in Alhambra 2 days, and they're all independent cities. Some have their own minimum wage. What minimum wage do you pay? We always advise, as a chamber from your law firm, is pay the highest one. That that way you're covered.
I agree with that approach. Yeah, I definitely agree with that approach, Nancy. And it does sound like, if they're driving all over the place, you definitely want to pay the higher wage. And in this instance, especially since the $15 wage is going to be applicable effective July 1st, for the city of LA and the unincorporated areas, I would advise the $15 wage and just get it done and sleep at night, not worrying about it.
Okay. And then the next question is, well, that means I have to change my pay, Eric, but okay. Are there any specific online HR courses that you recommend?
I mean, this is a very like loaded question, because HR courses is kind of a broad area, right? So there are various, well, first of all, Nancy, do you want to like quickly like talk about the chamber training program that may be applicable to certain industries?
Right. We have different types. The chamber offers different HR courses throughout the year, whether it's about how to apply minimum wage and the sick pay. We just had HR courses on how to hire right without getting, sued. So we do offer some. If you're a chamber member, they're free. They're $20 for non-members. If we partner with maybe your attorney, if that's Landegger Law Group, it might be how you're here today. We may have a code for them. And so we offer those webinars and in-persons at very reasonable costs. So if there's a certain course you're interested in seeing, if it's something we could get one of our members to do to help you, we'd be happy to do it. Because there's, like Kristina said, there's so many HR courses out there.
Yeah.
I take a lot through when I go to workshops and seminars myself, but they're all different, and sometimes they're tailored to an industry. I go to a lot of ones tailored for association and chamber industry because we have different requirements. So if you want to write back and or send me an email, outside of this and say what you're looking for, we can see how we can accommodate you.
Yeah, totally. And the other thing that, to piggyback on what Nancy said, depending on the size of your business, and you definitely want to pick something that's cost effective for you, right? And it may be a combination of things, right? I wish there was sort of a perfect thing that I could say, go to, www. Whatever, but there isn't. I think that many employers go around and find things that work for them. One of the things, in addition to what the chamber offers, which I think is really cost effective, is our free workshops that you can attend, which we typically do about once a month, and they are usually topic specific. For example, we train your managers on things like how to properly accommodate employees, or how to make sure that you comply with all the California and federal leaves, and things so on and so forth. So, I think between the chamber and our law firm, you'll probably find something. If you're looking for something very specific, like if you're looking, to train your staff in a very specific area, feel free to reach out to Nancy or myself, and we'll see, what it is that you're looking for, and try to suggest some things that are more specific.
So this next question, I could actually answer pretty well, then you can follow up since I do this all the time. How does the late penalty for wages work with missed late meal penalty? So in our office, many times my employees have to work through lunch, even if it's a lunch, like where we're serving our members a lunch. So for that day, I have to pay them their 8-hour day, and they still only worked 8 hours, but then I have to pay an extra hour because they missed their lunch, and that's the penalty. So I have to pay the minimum wage for 1 hour for that missed lunch period.
Yep. I have nothing else to add. That's exactly right.
So, but if your employee works 9 hours and they miss the lunch, then you have to pay them 8 hours, and then you have to pay them overtime for that,
Yep,
that
that's
9th
exactly
hour,
right.
and then you still have to pay the 1 hour for the missed lunch.
Yep, that's correct.
That's my pro question. Yes, you'll be receiving a copy of this. The presentation actually will be posted on YouTube, hopefully by the end of today. Does the late wage pay become effective on anything violated since January 1st, 2020, or paid since January 1st, 2020, due to an error that was made prior to January 21st, 2020? So if that late wage issue happened in 2019, is the late wage penalty still affect them?
That is a really good question. And to be honest, I am not sure, because the law is so new. Now, in terms of this, so the response is the following. Assuming the employee is still employed, I would say that is a good question, because I don't believe the law is retroactive, okay? So the new law that allows for an employee to collect a penalty if you're, an existing employee on late wages applies beginning January 1st, 2020. So, this is something that I'd have to look into because the law is so new, to see if it actually, if an existing employee can go back and say, you know what, about 6 months ago, like I was not properly paid or I was not timely paid. So I'm happy to look into that for you. Whoever has the question, so contact me and I'll look into it. And
I'll have you look into it and I'll send it out to everyone.
That sounds good.
There's
but
some people on the call that might be interested.
But so that's for existing employees. And obviously, if the employee, was terminated, then, then yes, you would be entitled to penalties under Labor Code Section 203. Okay.
Okay. So we're good with that
up to 30 days of wages.
Okay. So the next one is on the sexual harassment training with almost 100 employees. Is the extension the extension was to January 2020, or has it all been extended to 2021?
It has all been extended to 2021, January 2021.
Great. Should all these
and
updates...
for that many, and Nancy, I'm sorry, for that many individuals, I definitely recommend an interactive in-person training, which, I would be happy to do for you.
And we have other members that offer it as well. Sorry,
exactly.
I'm going to keep throwing that in.
Please, by all means.
Someone wrote this lower down, but I want to go back to it because this was a question we had in our office. The no rehire provisions. Someone steals from me.
Yeah.
And I still can't say I can't have a no rehire in that.
This is a really excellent question, because the only exception is with respect to sexual harassment. So I really do.
They could basically embezzle $10,000 or $10 million or even $200, and they're eligible for rehire. And
exactly. The only carve out at this point seems to be the carve out with respect to sexual harassment. But again, this is very, very new. So we're all still trying to understand the parameters of it. And I'm happy to look into this further, and I'm sure I will be for many of my clients. So,
and I'm sure we'll hear from the California Chamber.
Yep.
So I'll look into that.
Absolutely. And a lot of these laws are already being, as we all know,
they're all being challenged right now.
They're all being challenged because of the limitations that don't make any sense.
Yeah. Okay, so next question. Should all of these updates reflect in your handbook? Now, I'm just going to throw this out there. I think you need to talk to whoever's doing your handbook, because some of our changes didn't go into the handbook. They went into our policy manual.
Okay, so
and that was, by the way, with Kristina, with you and Kylie, because I talked to Kylie and she's like, well, that's not really a handbook question. That's more of your policy, so I think you need to check with your right source.
Let me tell you the ones that, and you'll get handouts at the end of this presentation for the laws that are absolutely required for you to include in your policies. Okay, so you'll know the answer to this question once you get the updates. Okay, so there are a few laws, for example, the lactation policy and the Crown Act. The relations. The Crown Act policy, because it is a state ban on discrimination with respect to hairstyles. That should be written policy regardless of how many individuals you employ, as well as the lactation policy. Those things have to be in writing, okay? So if you don't have them in writing now, you should have them. Take the handout that I'm providing and make sure that you implement it. The other thing is the California Paid Family Leave pamphlet. Again, it's one of the handouts that you'll receive today. It's both in English and Spanish, depending on your workforce. You must provide that. It is a state-mandated, written document that you have to provide to your employees. Other things like the IRS standard mileage rates and the minimum wage chart and the salary chart, again, use your discretion if it applies to your employees. But these are all, state mandated forms. One other thing that I can think of off the top of my head right now is there is a new updated W-4, W-4 form that's new, and it's a 2020 W-4 form that you really have to be using instead of the old one. So make sure that you download the new one. And
you have to give that to your existing employees too?
No, actually, I'm sorry. That's only for new hires. Okay, it's not for existing. It's only for new hires. Okay, so moving forward, beginning with January of 2020, you need to have the updated form. Okay, those are the ones that I can think of. But, you know, I'm happy to send out to whoever contacts me a free, you know, checklist as well as the actual required forms. I also throw in some recommended ones, but there's definitely forms you want to make sure you have, you know, in writing, depending on, you know, how many employees you have. I may recommend an employee handbook, but definitely have these forms.
Okay, great. What is the rule about labor postings when employees work from home? This is such a great question because we sell those poster sets, but I just saw a company that's supposedly offering them mobile too. So that's a good question.
Yeah, you definitely want to have them posted somewhere, okay? And
if employee works from home, what do you do?
Yeah, employee works from home, you definitely want to, it's a really loaded question, Nancy, right? Because are we talking about a true employee or are we talking about an independent contractor?
Let's just say they're a true employee, okay? The employee works from home.
Yeah. If
that's
they
the question the person's giving us. So they're employed, they're not an independent contractor, they work from their house, they telecommute.
Right. So there has to be, so here's the thing. In all situations where we have a threatened matter that, you know, where an employee is claiming, oh, you know, I was never provided, you know, meal breaks or rest breaks, they basically say there was no written policy, okay? So you definitely want to be able to show, no, there is a written policy, okay? And a poster will definitely be one of those, will fulfill the requirement. So make sure that you have those posters, even if you have employees who work from home, okay? Now, whether it be at a home base, I don't know where that is, okay?
So if my employee works in Granada, they come in my office once a month. They telecommute because they're a salesperson. So they only have to come in once a month and do a sales meeting with me.
Yeah.
So they may not see that labor poster or they don't go to my break room. So let's just say that's the situation, or they're quarterly, or maybe your employee works in a different city. They work in San Francisco and they're still an employee because that's your remote place. How's the law cover that? This is not the first time we've had this question.
Right. My recommendation is that you must have a written policy, okay? So your written policy must cover a meal and rest break policy, an overtime policy, whatever that may be. It must cover all the things that a typical poster covers. Okay, now you must also, in addition to that, have a poster that's required by the law that, you know, Nancy, the chamber provides, or whoever provides, that you must post in your regular place of business. In addition to that, okay, that's what I recommend.
As long as you post it, and then you're giving them an employee manual that has this information in it as well, you should be covered.
You should be covered, but I cannot emphasize enough, if you have employees who are telecommuting or working remotely, you must absolutely have written policies that you send to them. And if they, you know, upon new hire, they must review and sign them, and you must have a checklist that says, you know, Jane Smith has reviewed and signed these policies. Okay, and in addition to that, at your home base, you should also have a poster.
Well, yeah, everyone should have a poster at their home base. Because you know, this has been for a couple of years. Employers with remote workers must consider how to address. It's a new trend, and it's sure to be compliant.
For sure. Yeah.
So
they have absolutely. So there's you know.
So the other option is, to me, this is me saying this as the chamber. A lot of these posters, you know, no one wants a big, like, have 10 million pieces of paper because there's 17 posters stapled to their wall in their break room. But all of those posters are available on the individual websites of the agency that's issuing them. You could download those and email those to those employees too.
Yeah, there you go. You can do that. Absolutely. As long as the employer is providing a written policy and, you know, making sure that it's out there, then, you know, God forbid you have a lawsuit or a class action on your hands, the first thing they plead is, we had no idea we could take breaks. We had no idea there were, you know, meal periods. It was never communicated to us. And guess what? Many companies don't. They think, oh, we said it in the orientation. It was verbally communicated. Not enough. Get it in writing. You know, have a poster. send an email with all the, with all the forms, get them to sign, and then I would have an acknowledgement of receipt in addition to all of that, because an acknowledgement of receipt states that I read, received, and understood your policy, and here's my signature showing that I did. That's the best practice.
Right. Okay. So we've answered that one. What is the best place to find the list of AB5 exceptions?
I mean, you can Google it, but honestly, I wouldn't wing this. I would not wing this.
It's changing daily.
Yeah, it's changing. I'm getting daily updates, but if you want to go and get the actual, bill text, you can Google it and get it, at the, the California legislative information. You'll at the very least get the text of the bill, the Assembly Bill number 5. And it has currently, it was published in September of 2019, so you'll get it as of that date. But again, there are lots of updates that are, that are being made. As of now, none of them are, in effect. However, so if you want to get the text of the, of the bill, go ahead and Google, bill text AB5, and you'll get the bill text. You'll be able to go through it and look at the exceptions.
You could go to legeinfo.gov, put in AB5,
yeah,
and click the latest version.
Exactly, and you'll get the legislative info for it. Yeah, and then, if you have any questions and you're having trouble sifting through it, feel free to contact me or Nancy. We'll put you in touch with someone who can help.
Just since Kristina did this PowerPoint, some new exceptions came in, so we can't even keep up to do the session. For
sure. I mean, this thing's being challenged as we speak, so it's very fluid. It's in a very fluid state.
Next question. On AB 51, can you elaborate on the mandatory arbitration agreement?
Sure. So, and when you say elaborate, so I want to point out that this is only beneficial to companies that are big enough. Okay. And when I say big enough, I mean, let me give you an example. One of my clients, in order to arbitrate, was basically told, hey, if you pay like, over $100,000, I can't remember what the number. It's basically like, for you to arbitrate, you need to pay an X number of dollars that's over $100,000 to even get in the door. Okay, so the fees always fall on the employer. Okay, there are certain costs that the employee will pay for, but the majority of the fees are supposed to be covered by the employer if you want to go the arbitration route. The other thing that, can be very beneficial to you if you're large enough is the class action waiver option. Okay, let's say you have, hundreds of employees and you can really benefit from dodging a class action. Then I definitely recommend that you go that route. However, again, even though you can waive a class action, those same employees can come back and bring what's called a PAGA claim, a private attorney's general act claim, that will entitle them to band together. And a PAGA claim goes back, 1 year from the date that it is filed. So a complaint is filed, it goes back 1 year. It loops in all the employees who were employed, whether or not they're still employed in that 1 year. And they're allowed to allege, wage and hour violations, and it only requires one employee to bring that type of claim. Okay, so Joe Smith brings a PAGA claim, loops in, 400 employees who were employed a year back, during that relevant time period, and seeks penalties under the, under PAGA. And it can be a very, very expensive claim, right? So now you're stuck litigating a PAGA claim, and under your own arbitration agreement, you may be stuck arbitrating them. So it's very expensive, right? And because it's not a class, they can end up filing like 10,000 different lawsuits. So it can either be, it can either be a great tool or it can be a thorn in your side. So it really depends on, on your needs. And I'm happy to provide a free consultation about arbitration if this is something you're really curious about.
Okay. Next, so we've got 20 minutes. Let's try to breeze through these if we can. Some of them I'm trying to answer in emails to people.
Yep.
Will the independent contractors still apply if done 50% virtually and 50% at the client's office? For instance, administration help, is there a percentage that goes over to the employee?
I'm unclear about the question.
So,
Administrative
well, they're saying
help.
if you have an independent contractor, if 50% of the time they work on their own somewhere, but 50% of the time they come to the client's office. I'm going to say like a bookkeeper, for instance. They have their own clients, but they come in
It doesn't matter.
once a week. But at some point, do they have to pay them as an employee when they're in their office?
Right. And here's the thing. It really depends on the nature of your business, right? So if the employee can somehow, you know, fit into any of the exemptions under AB5. Let's say that you have an employee that, you know, shows up 50% of the time and is working in the office, and the other, you know, the rest of the time they're working from their own, you know, address, right?
Right.
So depending on the business, it really depends on what is it that they're doing for you, okay? Because depending on what they're doing for you, they may actually, you know, overcome the presumption under the dynamics decision, okay? Now, under AB5, depending on the types of services they're doing for you, they may qualify for, you know, the professional services exemption. So let's say they're doing, you know, a type of service that falls, you know, that falls within one of the exemptions under the, you know, the professional services exemption. Let's say they're, you know, they're one of the professions that falls within that, you know, that list. And if that's the case, then they would be subject to the Borrello, not the dynamics test, right? So under the Borrello test, we would look and see, okay, are they, you know, do they have a license? Do they advertise themselves? Do they hold themselves out to, you know, to the public as performing the X service? You know, do they work at an independent location? And that one would sort of be, you know, in a gray area, because, you know, 50% of the time they work for you in the office, 50% of the time they work, you know, at their location. So that one would be a little, you know, a little bit risky, okay? But I would say that this really has everything to do with what they're doing for you and what the scope of your business is. And, you know, then
so we'll have them contact you because we have a few more questions and I want to get through them.
Yes, absolutely. Feel free.
Quick one. Does the private room require a fridge for lactation law?
You know, no, it doesn't have to be a fridge. It can be an ice, you know.
But does it have to be in the private room, or does the fridge, can that be in another room and then you go in the other room?
No,
okay.
it can be within a reasonable, you know, I mean, if they have to walk like 5 miles to get there, then the answer is no. But if it's somewhere within reasonable proximity, yes, that's fine.
Okay. I'm going to try to combine some of these together because they're similar. So you have an employee who they already missed a meal. Does that make the late wage penalty apply? These are all late wage penalty.
Yeah. A missed meal basically requires a, you know, premium pay. Okay.
But do they also get do they also get into the late wage penalty?
No,
okay.
No.
So they only have to pay the missed meal penalty of that extra hour of minimum wage?
Yes, absolutely.
Or minimum wage, whatever their hourly rate is.
The late wage actually applies to the actual, you know, like a paycheck being late. But yeah.
Okay. Do the late wage penalties apply to reimbursements? Like, does it begin the day of expense or the day they turn the receipt? Like,
no, because reimbursements are not considered to be wages. Okay. However, you have to be very mindful of and also there's absolutely no requirement for timing as to wage reimbursement, as to expense reimbursement. So you can have, as long as you're abiding by your own policy to reimburse regularly, right? And I do recommend that you have written policy that states, you know, so often, whatever, every 3 months or every quarter, this is when we reimburse for expenses, and this is the problem.
But it does not apply to the late wage penalty. I want to try to get through these questions as we have 10 minutes.
It does not.
Okay. for the late wages scenario, an employee did not clock out at the end of the day, and they never redressed the issue, and payroll was completed. How should the employee be paid for that day, since we did not know that when they stopped working? If we pay retroactively, once we can identify the clock out time, does that mean we are subject to late payment penalties?
The answer is no, because it's not your own doing. As long as there's a written policy expressed and the employee fails to follow the policy, then it's on them. It's not your willful violation, okay? So you just basically pay them as soon as you discover it, and you'll be fine.
Okay. Is it still a minimum 30-minute meal break for an 8-hour day?
Yes.
Okay. And are independent contractors supposed to have insurance in order to pay them? So basically, what do they need to provide companies to make it known they are independent?
If you look at the PowerPoint slide that has the Borello factors, I would, depending on the industry that you're in, I definitely do recommend insurance. I do recommend, general liability insurance up to at least $1 million, and depending on the industry. Absolutely a business license. I'm sorry, I thought the question was about insurance. Absolutely a business license, because you have to show that you're running an independent business and operating out of a different location, and you have insurance to cover your operation.
That's part question. It's two-part question. The other is, what do they need to provide companies to make it known they're independent?
What do they need to provide to the company that they're
so if I hire a bookkeeper, what does she need to provide that she has her own business so she doesn't get the whole employee thing?
Right. I generally recommend that, they provide a business license or any other license on top of that. For example, a bookkeeper or CPA may require an additional, specialization license that they provide their own, something that can show that they have the expertise, some sort of a syllabus or a resume. Essentially what's required under AB5 is that they have their separate address, okay? They advertise themselves, hold themselves out as a separate business, that they generally contract with others. So if they come in and say, hey, I'd like to work for you, 40 hours a week plus overtime, that isn't going to fly over well, because you want to be able to show if an agency comes and audits you, you want to say, hey, you know what, I do this for like 10 other businesses, or at least 2 other businesses, okay? And I would say that that's it. And depending on the industry, for example, if you provide staffing services, just an example, you want to have a written contract, okay? That's the requirement. Okay, so if someone comes in, a bookkeeper, a staffing agency, whatever, you say, you know what, let's put together a contract for the services. It's going to be a business-to-business services agreement. Under the agreement, these are going to be your responsibilities, including that you'll do X, Y, Z, and it may require, X number, dollar liability insurance, right? Like, let's say you're a staffing business, I recommend, $1 million liability. Maybe you require them to have some sort of, EPLI insurance, but that's really the bare minimum, and a business license for operating their own business.
Okay, great. So then the next question is, can you please expand on the AB 61 gun violence issue? I didn't understand if something is required by employers. Yes, I found that very confusing too.
Okay, so let me go there. It's kind of it's a very vague question, so I'm not really sure what it is that that they want to expand on.
They're not asking to expand. They're saying we didn't understand, is something required? I didn't understand what I'm supposed to do at all.
Okay.
When you explained it.
Yeah, absolutely, and I'm actually going there to see where I went wrong, to make sure that I supplement appropriately. So, first thing you want to be mindful of is that it's effective, September 1st of 2020, okay? And I think one thing that may be confusing is that if you're an employer, okay, if you're employing employees and or a coworker, so here's, I think this is why it's confusing. So it's either an employer or a coworker who has, open quote, a substantial and regular interactions with a person who is being restrained, and with approval of their company or employer, may seek an ex parte court order for 1 year or renewed gun violence restraining order against an employee or coworker. So I think what that really means is that if there's someone who is being restrained in the company, then you may seek what's called an ex parte order, which means, it's relief on a timely, shortened basis. Ex parte is basically like immediate relief for up to 1 year, okay, that provides you with a restraining order against an employee or coworker. So you may seek that relief if you're either an employer or if you're just an employee. In other words, you have a coworker who has, regular interactions with a person who is being restrained. Okay, does that make more sense? So
it's very confusing, I think, because we need to move on to the next question. We'll have to get an answer.
I'm happy to provide more information. It is kind of loaded, but no pun intended.
It's really a complicated question. Okay, regarding paid family leave extension, which was effective, which will be effective July 1st, 2020, and be reevaluated on January 1st, 2021. Does that mean the extension is only 8 weeks for the 6 months between July and January?
Yes, the answer is yes. That's what we have so far. But I'm sure we'll get updates before then.
Okay, then I have one more kind of question, which I already addressed, but I know other people probably have this question as well. So I wrote it to the person. What required pamphlets are there? And I responded to them because we actually have them available here.
Yeah, we do.
I'm about to do an order. So the required pamphlets that you need to give to employees are sexual harassment, workers' compensation rights and benefits, state disability insurance, paid family leave, unemployment insurance, rights of victims of domestic sexual assault and stalking, not like Christmas stockings. We offer a kit where there's 20 copies of each of these 6 pamphlets, so there's 6 different ones, and they must be distributed to employees, and we have them in English and Spanish. So that means there'll be 20 of each one of these. We're going to offer them to everyone on this call today for $75 plus tax and shipping. They are a special order, and the order may not be placed till next week because it's a special order. So if anyone's interested, I'm going to be sending out our order form or our link to our website as well. And that's our last question. So with that, I really want to thank everyone. We do have another webinar coming up, not similar to this, but if your website is not compliant, you could be sued. And there's all these new